wherever you might be watching this. So it's evening here in Nigeria. It is my pleasure to welcome everyone to another edition of JBLLC's mentorship session. My name is Senator Lawuni, and I will be anchoring this mentorship session with Khadija Alade. Khadija, would you mind unmuting yourself and saying hello to everyone here?
Hello, everyone. Good evening. It's nice to be here, and I'm glad to co-host with Anna today. Thank you, everyone.
Thank you, Khadija. So before we move on, in case we have first-timers, newcomers, observers, I would like to expatiate on what JBLLC stands for and what JBLLC means. The JBLLC literally means Johnson Babalola Law and Life Compass, and it is a mentorship platform for youths. So it is focused on youth mentorship, youth development. So it's a platform where you can develop your leadership skills, professional skills, and also exercise your critical thinking and analytical skills. We have a wide range of activities. We have our weekly questions of the week. We also have our mentorship sessions like this one. We have our bi-monthly quizzes and so on. So for anyone who might be interested in joining the platform, maybe after the mentorship session, the information to do that will be pasted in the
Hello?
Hello, sir.
Okay. We lost you there.
I'll be taking over while Anna works on our network.
All right.
Good evening, once again, everyone. Thank you so much for being here. Information as regard joining the group will be shared immediately once we are done with the conversation. First, before we proceed, I would like to read the back. Okay, Anna is back, so I'm going to give it back to Anna.
So sorry, everyone. So we have the honor of having our distinguished speaker, Mr. Ayo Olorunfemi, to enlighten us on this topic. So before I go on, I would like to recite Mr. Ayo Olorunfemi's citation so that we can all get to know him better. Mr. Ayo Abraham Olorunfemi, Senior Advocate of Nigeria, is a highly esteemed legal practitioner with a distinguished career spanning over 3 decades. He graduated with honors from Ahmadu Bello University and later obtained a master's degree in law from the University of Lagos. Mr. Olorunfemi has specialized in Admiralty and Maritime law, with recent expansions into oil and gas, banking, and corporate commercial law. Throughout his illustrious career, he has held various leadership positions, including managing partner at J.O. Ajewole and Company, David Jeremy Bewon and Company, and Femi Atoyebi and Company. In 2024, he founded his namesake firm, Ayo Olorunfemi SAN and Co. Mr. Olorunfemi is a fellow of the Nigerian Institute of Management, Chartered, and the Notary Public. He was elevated to Senior Advocate of Nigeria in 2021 and inducted into the American Biographical Institute Hall of Fame for Admiralty and Maritime Law in 2009. He has made significant contributions to legal scholarship through his publications, which include works on shelter rights, mortgagee obligations, judicial jurisdiction, and maritime law. Mr. Olorunfemi is widely regarded as a thought leader and a leading expert in his field. Ladies and gentlemen, can you join me in welcoming Mr. Ayo Olorunfemi with your virtual reactions, which you can find at the bottom of your screen, as I invite him to take the stage.
Thank you very much, Ms. Hannah.
You're welcome, sir. The floor is yours.
Thank you for the beautiful recitation. Let me begin by thanking my good friend, Mr. J. Johnson Babalola, and the entire team for inviting me to deliver this lecture, if I can say that. I'm grateful to be part of this great team. I want to thank the team, and particularly I could see that some great men and women are already on the platform. I want to thank judges who are here, learned advocates who are here, and my good friends and classmates that are here, and other lawyers. Yes, kindly help me share the paper on the screen. We all know that Admiralty or maritime law is a specialized field of practice, and it has international dimension to it, or international character. It is complex, as it is also simple. It is important to familiarize ourselves with the practice of maritime or admiralty. If you want to specialize in that area of the law, we found that over the years, a lot of claimants come to court without adequate knowledge in admiralty. And when they try to apply the normal practice, what you file in the normal civil court, you find that your client's claim may be defeated on technical ground. So I've always advised that we get familiar with this specialized area of the law. Now, can you get to this first page, the slide? Yes. Now, ship arrest is one significant area or part of maritime law. Why? Because it offers an advantageous character for any claimant who is going to court, and it's one of the few aspects of the law where you can get security even before the action is completed. In other words, before judgment. So we started by saying that ship arrest is a vital legal tool in maritime law. It is used to secure maritime by detaining vessels. You see, detention of vessels is made possible because ship or vessels have been known to cause damage while traversing the seas, while traversing the oceans. It could be as a result of collisions, it could be as a result of trading, maybe cargoes that carried charter parties, bill of lading, and maybe there were damages, that occurred on the vessel. Admiralty developed to say that the vessel can be allowed whereby it gives security. There is a legal feature to the effect that while this vessel can go, the vessel is regarded as the wrongdoer. Being the wrongdoer, it can be sued in its name, and so can it also sue against other interests. So there's a legal personality attached to a ship. Now, before I go further, we need to understand what action in rem is and action in personam. For action in rem, we simply mean that you can proceed against that vessel or what we call a res or a thing. It can be a freight, can be a cargo, it can be the proceeds of a particular vessel that has been sold. So it is made possible that you can proceed against that ship. So an action in rem is an action against that particular thing. Now, we will go to the specifics later, but the procedure for arrest, I categorize them into two. There is the general procedure, and there is this specific procedure. The general procedure is that before you proceed to court at all, there are things that you ought to have settled in chambers. You must know whether the claim that you're about to file can give you the result which your client wants. How do you know that your action is one in rem, whereby you can attach or arrest the vessel? When you detain the vessel is supposed to give you security. But if you don't know how to situate your claim within the provisions or the specifics of the law, it will later result in your action probably being struck out. We've had series of cases in the past whereby a party comes to court. I recall a particular case called Kema Shipping against MT Sindigaya. In that case, the point of dispute was that the plaintiff alleged that he had a deal with the broker to purchase the vessel called MT Sindigaya. But that broker went behind him and sold the vessel to our client. So he went to court to try to, he joined the vessel, joined our client as the new owner, and joined a sister vessel. Obviously, you could see that the relationship here, there was no connection at all, no nexus between their client and our client. The client that he related with was the broker. And that at best could be classified to be a breach of fiduciary duty. So that even if all the things that they pleaded in their statement of claim were to be admitted, it couldn't have led to the relief that they came to claim. So we had to file an application challenging it on the ground that it disclosed no reasonable cause of action. And the trial court agreed with us, struck out the case. Appealed to the Court of Appeal, unfully. Same thing to the Supreme Court. So that is to let you know that if we didn't do our homework very well, at the beginning, you could lose what would have been a good maritime claim pursuant to in rem action. And then when you consider your claim properly, you could see or find out that maybe there's no need to proceed in rem. It may not be a matter that you could arrest the vessel. So action in rem allows claim against the ship itself. But then we must ensure that we check the law. What are these laws? Can you help me go to the second slide, the next slide, please? So it's still going to explain that what an arrest means. So when you understand what an arrest is, it is a legal restraint or seizure of a ship via judicial order. It must be one that a court will give. Normally, the court will give what we call a warrant of arrest. That warrant contains in it what you could term the imprimatur of the president. It is issued in the name of the commander-in-chief of the Federal Republic of Nigeria. Ship will now be a defendant. Don't be surprised when you hear the term she or her being the feminine attributed to a ship. It is for the legal fiction that I mentioned about much earlier. So a ship can sue and be sued. Now, a legal arrest or warrant of arrest or an arrest of a vessel must not be confused with seizure in execution of judgment. That one comes into play after you have gone through the rigors of trial, and then you are now executing the judgment of the court on the particular asset. But for a ship arrest, once your arrest application succeeds, it is not a judgment. It is something in lieu of that judgment. It is an order given by court to give you security for your claim, subject to you proving facts that you pleaded or you have had in your pleadings. So an arrest is different from a seizure in execution. Next slide, please. Now, we have said, still going by the general procedure. Now, these are the most important legal framework for maritime matters. If you want to know whether your claim falls within the Admiralty jurisdiction of the court, you need to check the Constitution of the Federal Republic of Nigeria 1999 as amended, and you need to check the Admiralty Jurisdiction Act. Principally, you see section 1 and 2 there to understand what could be termed as maritime claims. Under that act, you will see the general maritime liens. You will also see the proprietary maritime claims. Now, there is also the Merchant Shipping Act. Principally, you see all these provisions deal with maritime maritime claims, particularly if you want to know whether and the court that will have jurisdiction over your claim. So there's also the rules which have been made as the handmaid to justice for the substantive acts. This is by no means exhaustive, but they are the principal legislations for you to check, if your claim can succeed under maritime claims or not. Next slide, please. So we must realize that the rules of court, the rules, the Admiralty Jurisdiction Procedure Rules 2023, which provide the procedural guidelines for arresting ships. Now, we need to also know when you go to court or you're about to go to court, what are the things that constitute security? When you file your action, what are the things that you expect the defendant to give to you or to provide for the release of the assets, which in this case could be the vessel or the cargo, the freight, and what have you. So under the rules that I just mentioned, AJPR 2023, which is the latest now, we have all these undertaking funds, letter of undertaking, that's number one. We also have bank guarantee. All these are undertaking that the defendant gives to tell the plaintiff that if you are to succeed at the end of the day, I will pay up. The LOU mostly are given by organizations known as protection and indemnity clubs. The ones recognized under the rules are those who are members of the international group of this P&I club. They're essentially like insurance company, and they are very big. They're actually bigger than most Nigerian banks. And when they give you security under their letterhead, it is as good as money. But unfortunately, you see that Nigerians, most claimants here, they don't recognize the importance of a letter of undertaking. They believe that a letter of undertaking, because those people are not here, they will not honor their undertaking, but that is not true. So there is bank guarantee given by all Nigerian banks. All Nigerian banks now are very, very good. Unlike before that, some of them were being liquidated, they had problems, the share capital were not enough so they actually went under. But most bank guarantee given now for easy access to Nigerians, they are also good. There's also bail. You can go by way of cash deposit. And there's also insurance companies. Insurance companies can give security to cover your claim as an applicant or as a plaintiff or claimant before the court. And it is important for us to know that the proper court is the Federal High Court. Unfortunately, of recent, one of the principal claims that usually fall within the Admiralty jurisdiction of the court had been taken over by the National Industrial Court, which is masters' wages or crew wages, so that unfortunately for the crewmen, they can only go to the NIC, National Industrial Court, and will not be able to get this advantage that security offers. Next slide, please. So maritime claims has been defined under the Act the AJA 1991. That is still the extant law. And it has been divided into two. You find proprietary maritime claims. They call it proprietary maritime claims. Claims for ownership, possession, mortgage, and freight on the vessel are categorized as proprietary maritime claims. Then you also have the general maritime claims. Cases of damage may be occasioned by the vessel, loss of life on the, it can be the vessel of equipment inside the vessel causing loss of lives, cargo damage, maybe you were importing rice and there was ingress of water damaging or taking the rice. When you come to Lagos or any of these coastal cities where you have the Federal High Court, you could also institute an action there. So general maritime claims, salvage, towage, pilotage, where you have the pilots, the local pilots navigating a particular vessel and causing collision, maybe against the jetty or against another vessel. This is one of those claims categorized as maritime claims. So when you have your client in a particular matter, you must situate the facts within the definitions of what constitute maritime claims as defined under the Act. Next slide, please. They're all based on the AJA 1991. So classification of actions. I think I touched this on briefly. Number one is that action in rem is directed against the ship or property. When you say action in person, it is directed against the individual, such as the owner or a company. And there is a key distinction that we must really emphasize, because obviously, or at the end, it will affect the jurisdiction and the process and enforcement. There have been matters, going by this definition that we've just given, there have been matters that have been needlessly struck out. Why? Because the claimant combined both in rem and in personam action in the same originating process. In fact, under the old rules, the 1993 rules, there was a specific provision there which bar you from combining in rem and personam actions in the same originating process. And the problem here is, if you combine in personam action and in rem action in the same process, and one of the defendants is resident outside jurisdiction, then you need to now comply with the other aspect, like the Federal High Court rules or other rules relating to in personam actions. In fact, in England, there is what is called the in personam rule. And it is to the effect that you cannot file an action against a foreign defendant without obtaining leave of court first. And Nigeria is by no means an exception. There's been a decision by the Supreme Court in the MV Western Star, which unfortunately had to strike out the plaintiff's case because he didn't obtain leave before instituting the action. I mean, what the confusion arises because most claimants don't realize that you could just sue the vessel alone and then give your particulars. In your pleadings, you have to tell us who the owners are, the relevant person, who the beneficial owners are. Section 5.4 talks about the relevant person, the person you had transaction with, who was the owner at the time the cause of action arose, and then at the time of filing the action. Can we proceed? I think we are running out of time. Next slide, please. So the procedure for now, going to the specifics here. Now, after ensuring that your claim is one that qualifies as in-rem claim, having scrutinized it under the AJA, the Constitution, and the other principal legislations, like the Merchant Shipping Act, and even the rules of court, you must go and search the caveat registry of the court to see whether any party has filed a caveat, what they call a caveat against arrest. And that is an instrument giving notice or warning that this vessel is not to be arrested. The owner or the particular interest is ready to give security to a certain level of amount, to a certain amount. So once you have done that, and now it is even important that you write a letter which must be endorsed, and then you must state it in your affidavit that you have taken this step. Then the next step is to file a writ of summons and submit your claim with documents. That writ of summons must be filed simultaneously with a statement of claim. Then you file, all these things must be ready together. You file an ex parte, prepare and file an ex parte motion for arrest warrant. Evidently, like other ex parte applications for injunctions, it must have a supporting affidavit and then an affidavit of urgency. So these are the things that one must file, like other including costs. You must, I believe we all know that you have, apart from statement of claim, your written statement on oath, your list of witnesses, the list of documents and non-documentary evidence, all those things, you must get them together and then file in court. You must also give an undertaking as to damages, because that's the price you pay. Just should it turn out that your claim should not have been brought in the first place, because a lot of frivolous claims are filed just to get the owners to, or frustrate them, just to get them to some frivolous claims. So if you know that your case is frivolous, you must not go ahead to file an application to arrest a vessel. Why? Because vessels, apart from being so big, they so much, and just to maintain per day. So when you arrest a vessel, it is losing so much, thousands of dollars, some of them as much as $25,000 daily, even others like $50,000 daily. So the court do not play with such applications if you know that it has no good ground to stand on. Next slide, please. Now, after successfully obtaining an order of arrest, how do you serve it? The master of the ship, that the person in control of the ship, is normally the first person that you know that is most important. Let me not say most important, because we found over the years that where you first serve the master and is still in the anchorage, it may disappear. So there is the NPA, the Chief Port Harbor Master, is now even the designated person. Now, at times, you may need the Navy or the Customs so that they will provide security. Why? Because some vessel captains have been known to escape arrest. So the naval agencies can board the vessel to maintain security there and ensure that the vessel does not bail. So you serve the MPA, you serve also the order on the shipmaster himself, then the Admiralty Marshal or his substitute. So these are the important people to serve the order or the warrant of arrest on. Next slide, please. Now, it is important to mention briefly on release and security, because the duty of an arrestor does not end with just arresting the vessel. Most claimants have been known to arrest and then they try to disappear. We've had instances where claimants will arrest a vessel, like let's say in December, close to the holiday, and then you hear that the plaintiff solicitors or the plaintiff's counsel has closed down for the year. That is not right, because once you have arrested the vessel, know that there's an obligation on you to await the reaction from the interest of the owners or whoever, whether the charterers by demise or the registered owner. They will eventually come. So a ship is usually released on provision of acceptable security. Mostly the plaintiff will state this on the face of their motion paper. It may say, well, upon provision of first bank guarantee, blah, 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 on the face of motion paper, and whatever bank that the person likes. But that is not to say that the plaintiff defendant, as a necessity, must now give that first bank, so long as is ready to offer any of the securities enumerated under the rules that we alluded to much earlier, whether the LOU, letter of undertaking by a member of the International Group of P&I Club, or another bank guarantee. Can be from Union Bank, can be anyone where he maintains an account or his agent maintains an account to be able to arrange the security. Security by way of bank guarantee is always a bit tedious, in the sense that Nigerian banks have learned their lesson. So the norm that there must be a backup security. So they will get in touch with whoever is arranging for the security to put the cash. There should be cash bagged in their account. And so it could take time to arrange this security, particularly where the defendant has no connection, or his owners has no connection to the bank being proposed by the plaintiff. So any 5 forms of security is deemed to be acceptable form of security. So release can either be conditional release, in other words, when the owner has given the plaintiff what he wanted or what he's asking for, or a substitute like the other forms of security. It can also be unconditional. In other words, where the owner says, you know what, I'm not ready to, this is a frivolous claim, I'm not ready to provide security, I'm ready to challenge the validity of this order or the jurisdiction of the court. But wise defendants or owners have always tried to provide security and with a condition that they will be challenging the jurisdiction of the court, so that the vessel in the first place can move on to continue trading while the legal fireworks goes on in court. There have been arguments that bails will be under protest, so that that it should stipulate in the body of the guarantee that, oh, I'm going to be challenging jurisdiction. But I'm of the different opinion. Security is a totally different form of, it has nothing to do with the jurisdiction of the court. And that is the opinion of one of these foremost legal writers on maritime law. Next slide, please. Now, another concept that we should have in mind as arrestors, when you are arresting a vessel, also know that if you either demand excessive security or you are unreasonable in the type of security you are asking for, you can be asked to intervene to fix the amount of security based on what we call the principle called reasonably arguable best case, which was espoused in the case of the Moschanti in England and has been adopted in Nigeria in the SRS cases. So that principle has been adopted. The principle is to say that looking at the case and your pleadings, your claims should be what you are. Let's say that you are claiming 1 billion. We had a case just like that, where they claim like the cost of that item was not more than $1 million. But the Nigerian claimant was claiming like 4 billion. So in such a scenario, the defender will be forced, there's no way you come up from authority. You will be forced to challenge action and ask the court to intervene to fix the amount. And there are principles to use for that. One of it is that the claim you are making or the amount you are asking for cannot exceed the value of the ship. If the ship is $10 million, for instance, you cannot come to seek security for $15 million or $11 million, or anything above. So the defender can come forward, or its owners come forward to say, we are only giving, this is the value of the ship, and you can verify it. We are only giving you $10 million worth of security. Now, one of the principles that we normally challenge is that a plaintiff must put all his cards fully on the table. You must state how you arrive at the figure that you are claiming. So your must be with particularity. You must particularize. If you are claiming that a particular cargo, maybe cargo of rice, how many are they? What's the cost per bag? You must state all these things. These are things that are not hidden. They are verifiable. When you begin to now claim that a bag of rice, for instance, if you are claiming is 200,000, meanwhile in the market is like 100,000 or 60,000, will now come for the court to fix the amount by asking that the amount of security be reduced. So if you have the capacity, you can first give what they are claiming, then come back, because you know that you'll be paying interest on this security. So you come back to ask the court to intervene to reduce the amount of security. Next slide, please. So we have touched on briefly, even though briefly, wrongful arrest, the consequences that where you proceeded to arrest a vessel wrongfully, there are consequences for it. So that is why the disclosure duty at an ex parte stage. Ex parte, for people who may not be conversant with court procedures, simply means you are filing the action without notice. That means the application without notice to the other side. So only you is being heard by the judge, which now means that extra care has to be taken. You must disclose all the facts, whether they are for you or against you, in your application. And then the details. If all those things are not clear, at the end of the day, your client may be liable for wrongful arrest. So, and damages can be awarded for excessive security demands and failure to consent to release, arrest in bad faith or negligence. There are instances where you see some counsel and their client, they will refuse to consent, even though they've arranged for security and they've agreed. Come to court, they will not want to come to court. So this could lead to consequences. And we must be aware of all this while proceeding to court. Make sure that you are ready to comply with all the dictates of ex parte applications and in rem arrest and demand for security. So never ask for excessive security demands. Like the example I gave, somebody asking for 4 billion instead of 1 million. And then you have arrested, you don't want to consent to the release just so that the owner will be under undue pressure to settle your claim. It's not done that way. Then arrest in bad faith or negligence. Maybe you are now arresting the wrongful party. Section 5.4 tells you that is of the AJA, that the party that you had transaction with must be the beneficial owner. First, at the time the cause of action arose, and secondly, at the time you are filing your claim in court. It must still be the owner. Otherwise, you will find that maybe it's the wrongful party that you are brought to court. Next slide, please. So this is another one, judicial sale. At the back of our mind, we must know that judicial sale may be ordered where, for instance, you have arrested the vessel, nobody is coming forward to defend the vessel, no one has shown up to take care of the ship, and the vessel may be deteriorating, and the risk there is that this vessel may sink and constitute a menace on our seas here. So the law allows you to file an application for the vessel to be sold on the ground that it is deteriorating, even though you have not proved your claim yet. So the vessel can be sold, and once it is sold by the Admiralty Marshal, having fulfilled all the conditions, the money, the proceeds of sale now replaces the vessel in court and can be proceeded against by the plaintiff or any other party of interest. So I've said it, where they have not provided security, you can also ask that the vessel be sold. This may force them to come forward. And if they don't come forward, once the Admiralty Marshal conducts that sale, any transferred is always considered to be free of encumbrances. Next slide, please. Now we have mentioned the privilege, maritime liens. This is another aspect of in rem claims that you can proceed to court for. You can always get, once your claim is one categorized as maritime lien, it is a privileged claim on a ship or cargo. And the one characteristic of a maritime lien is that it survives the transfer of ownership. In other words, even where the vessel has been sold without your knowledge to somebody else, the maritime lien still transfers, it goes on with it. So Nigeria recognizes this demise here as having qualified as maritime liens, salvage, damage, ship, crew wages, master's disbursement, they are considered to be maritime liens. If you have studied the previous law that we inherited, the Administration of Justice Act 1956, which was adopted later in Nigeria by the provisions in the AJA, and we extended it by including claims like this crew wages and master disbursement, which were not in the original something. So Nigerian law recognizes all this as qualifying as maritime liens, which will also allow you to commence an in rem action. Next slide, please. But let me mention that for maritime lien, only 1 year. It has a lifespan of 1 year. And then there's another one, if it is by collision under the Maritime Merchant Shipping Act, rather, is 2 years there. So if you don't ventilate your claim within those periods, you may lose it unless the court grants you a time extension before the expiration of the limitation period. Common law, you have a common law and contractual liens. This one, they are processory liens. For maritime liens, it doesn't have to be, it's not possessory. You don't have to be in possession. But common law, maybe you are carrying a cargo for somebody and you are holding it, like payment, you can hold on to it under common law or contract. Contractual liens in the sense that you have contracts such as charter parties, bills of lading, that has clauses retaining a right to lien the cargo being carried. So they qualify as contractual lien as well, which will entitle you, so long as the cargo is still within your possession, to hold on to it, sue the cargo and lien it. Next slide, please. So I mentioned the challenges in the Nigerian context. I don't want to dwell on this too much, but because our time is fast spent, so it's to say that in Nigeria, you cannot get an arrest of vessels owned by associated companies to the party liable to you, if they are not sister ship. The concept of sister ships here is that it must be the owner that owns the vessel, which is the wrongdoer. In this case, maybe it's only ship A and has another ship B. Even if ship A has escaped, if you cite ship B, you see you can join both and pass on the ship B. Why? Because they are owned by the same ship owner. But people are wiser now. You hardly find anywhere where, particularly those Greeks, where one vessel is owned, I mean, two vessels will now be owned by one company or individual. So AJPR 2023, Order 7, is actually Order 7, Rule 1, Sub Rule 10. I just mentioned a controversial restriction there. And then the AJPR, the differences, where you find that under the AJPR, there's this new innovation trying to infuse jurisdiction in the court, or imbue jurisdiction in the court to arrest a vessel solely for the purposes of foreign, it can be foreign arbitration or any arbitration, Before, there was no such provision under the former rules. But it's also doubtful, even though this provision is ingenious, it is doubtful whether it can be enforced. Why? Because even the 1991 Act, which makes in-rem claim compulsory by filing both, or by filing a substantive claim, has not been amended. So one wonders how a rule of court can now make that provision to say, okay, you don't even need to file a substantive claim. That's part of the controversy I was talking about. And then the second controversy under Order 7, Rule 110, has to do with a protection being offered. The provision there is saying that where a vessel is arrested and the ownership changes afterwards, only the general maritime claims can still stand. The court will still have jurisdiction over the general maritime claims. And I think that that would be wrong, because even proprietary maritime claims that are very important are not covered under that provision. But then it will appear to me to also be a conflict with the subsection 4 of the Act, the substantive Act itself, which gives the right or jurisdiction in court to arrest based on whether you have ownership of that vessel at the time the cause of action arose and at the time the action is filed. But under Order 7, Rule 110, it is saying that once the ownership changes by sale or disposal, the court will no longer have jurisdiction. So that's the challenge that I try to point out there. Next slide, please. So the key takeaways here is that ship arrest is a potent weapon, but that an arrestor must be responsible in using it. So jurisdiction and procedural compliance are crucial. Then judicial discretion and fairness should guide the process that you are filing. Next slide. So conclusion, the Nigerian Maritime or Admiralty law is evolving towards international best practices. Then arrest provides security, but must not be abused, since we know the consequences. Then all stakeholders must understand the law's nuances. The complexities in the law, whether you are the owner of the vessel whose vessel is being arrested, or you are the one seeking to arrest the vessel, you must understand that there is every need to be careful before taking action. Thank you very much for your time.
Thank you once again, sir. Thank you so much. Please, can we use the reaction button to give a clap to Mr. Ayo Olorunfemi SAN? Thank you so much, sir. Thank you for your time. Thank you for the expertise. Thank you for sharing knowledge with us on how to ensure that we know much more better on shipping and also the possession of ships. Thank you so much. From the discussion today, I've been able to understand that there are legal personalities that are attached to a ship. A ship can sue and can be sued. There is a difference between in rem and in personam. And it just made me remember that when we were in 300 level, during thoughts, we were taught about goods, carriage, and all of that. And it just made perfect sense hearing you talk about the ship aspect. And so once again, I want to say thank you, everyone. Thank you Mr. Olorunfemi SAN, thank you so much for your time, sir. Please, if you have any question, kindly raise your hand or put it in the chat box.
I'm sorry, I'm struggling to do that, but I have a question.
Okay. Is that Peace Adebola? All right. Okay. Mr. Abiodun, please go ahead, sir. You can ask your question. Thank you.
Okay, thank you very much. Thank you, sir, for the presentation. I have a question. Yeah, I know you were talking about some of the recent innovations that the AJPR 2023 brought, but I didn't exactly get that part. So I know that generally, in some places around the world, we have like a concept of statutory lien, which when you have sort of like filed your claim in rem, then the lien attaches to the ship, such that if the ship then changes ownership, I mean, it's already attached to it. So I wasn't really sure if what you were saying was that the provisions of the AJPR 2023 now alters that, such that even if you've instituted your errant claim, if ownership changes, then the court cannot have AREM jurisdiction again. I just wanted to be clear about that particular part.
Okay. Can I address that?
Oh, definitely, sir. Please go ahead.
Okay.
Thank you.
Yes, thank you. Yes, in a way, you see the position of the law, as far as I'm concerned, has still not changed, in the sense that maritime lien attaches to the res itself. So once you have exercised that lien, it travels with it. But I don't know what informed the drafters to couch that order 7, rule 1, sub rule 10. And what it seems to suggest to me is that that jurisdiction may be lost if ownership changes. If ownership changes at the time after filing the suit, and then the ownership changes. That's what to say. You have commenced the action. Then all of a sudden, maybe before you served or you effect the service of the arrest order, somebody now sold that vessel. It is saying that the court will not have risk for general maritime claims. And I'm saying that would be wrong. As far as I'm concerned, that provision of the rules is inconsistent with the provision of section 5, subsection 4 of the AJA, which gives jurisdiction to the court to arrest when the action arose, I mean from the time the cause of action arose and the time of filing the action, if the beneficial owner is still the same. So once we have filed the action, that knocks it off under section 5.4. And where there is a inconsistency, we all know, between the provision of statutes and the rules of court, then the rules of court must take the sideline. I'm saying that or that 7 rule 110 shouldn't have been there, or it should cover because the proprietary maritime lien that was even excluded, or proprietary maritime claims, they are very important, like issue of ownership of a vessel are being contested, or mortgage of a vessel. Does it now mean that once that thing has just, after you sued the vessel in court, and then maybe the wrongdoer just quickly sold that vessel behind your back, and then somebody will now come to court and say, well, the court has lost jurisdiction. So it's a new provision under the AJPR 2023. We, for me, shouldn't have been there. That's my view, though.
Yeah. Okay. Thank you so much, sir. I don't have access to the AJPR 2023, so I can't really have a look at these provisions now.
I can read it to you if we still have time. If you want me to read it out.
I'm not sure.
But if they,
yeah,
that is if we still have time, it's saying that except in an actioning realm based on a maritime lien commenced in relation to a general maritime claim. So it is giving exception to general maritime claim. A warrant of arrest shall not be issued by any court exercising Admiralty jurisdiction in the case of a ship or other property whose beneficial ownership has, since the issuance of the writ of summons, changed as a result of a sale or disposal.
Thank you so much,
So,
sir.
except,
We have another. Okay, I thought you were done. Are
yeah,
you done reading that,
thank you very much, sir. Yeah, thank you very much, sir.
Thank you.
All right, thank you so much, Mr. Abiodun, for your question. We have another question up here, and I'm trying to assess that. So from Okeson, he said, "Good evening, learned Sikh." I'm trying to ensure that. Okay, good evening, learned Sikh. I salute your expertise and vast experience. Can you give us a rundown of the cost of vessel arrests, such as, I'm trying to see this, okay, such as getting indemnity from P&I Club, bank guarantee, et al., and timeline? Thank you, sir. Do you want me to repeat that, sir?
No, say it again. The cost.
Can you give us a rundown of the cost of vessel arrest, such as getting indemnity from P&I Club, bank guarantee, and timeline? Like, what are the costs of, what is the cost to get indemnity? Yes, sir.
I understand you. It varies, and time is changing as well. There are times it depends on the bank that you are using. If it is the bank, I'm sure it can be very costly. For P&I clubs, because the members, like the owners now who are members of that, and they are paying their premiums, they're already paying premiums to their clubs. So the club looks out for their interest. So that one may not cost as much. But for claimant who is insisting they should provide a local bank guarantee, and the bank, we've had incidents like that it can take sometimes 3 months. We've seen like Zenith Bank one time that it took them like forever to issue the bank guarantee because the defendant's owners didn't have an account with Zenith Bank, and Zenith Bank, the corresponding bank abroad, no direct relationship, so they had to be moving in circles before they could get the exact claim. They have to pay it into court, inclusive of interest and cost. They'll pay it into the account of the bank, and then that bank will now issue the bank guarantee. They know if the other guy succeeds, then they are covered to pay. So it can cost as much as the claim, or even more. Why? Because they'll be paying interest. And we have also seen some banks, and I'm not advertising for them, there was a time before that GTB, okay, maybe because that they had a connection with them, within 3 days, they already came up with the bank guarantee. So it also depends on the amount you are claiming. If it's like $100,000 or $500,000 or $2 million, they may still be able to factor them in. But where you are claiming $10 million, $50 million, $1 billion, that can be very, very trickish. I hope I've answered your question, Mr. Question.
Hello, sir. Good evening, sir.
Good evening, Barrister.
Yes, sir. Thank you, sir.
Yeah.
Sir, you've answered my question partially. Okay, but sir, that in relation to Order 7 Rule 10, whereby the ownership structure of the vessel has changed. But sir, I've had a situation whereby the vessel owner immediately he discovered that they want to institute an action of arrest against his vessel. He quickly came up with another document. So the arrestor was asking him for bill of lading, and he could not produce the bill of lading or evidence of sale. So, sir, in such a circumstance whereby the vessel owner has decided to change the ownership structure of the vessel in order to evade liability, and there is no proof of such, what can one do in such a situation, sir?
You know, your question would depend on the peculiar facts, because the way you have said is not very clear. The bill of lading has nothing to do with the ownership, but if they have sold, there are documents you should be looking out for, particularly if they have sold before you filed. And it depends on your claim. Again, if it is a maritime lien, you can still go after it. But if it is not a maritime, you, like I said, you need to check provision of section 2 to situate your claim within the confines of those provisions, and then see whether it is such that can still proceed. No, because if you are not very forthcoming immediately, and you allow them to dribble you, and you didn't arrest quickly, and they have sold, you may not be able to fulfill section 5.4. Section 5.4 says the relevant person, in other words, the party, the wrongdoer now, must have been the owner when the cause of action arose, and then when the action is brought. So before you brought the action, if you had sold it, the second leg of the claim will not stand. Do you appreciate that? Do you understand?
Yes, sir, I do, sir. Yes. Thank you so much, sir.
Right.
And lastly, sir, I need a clarification. Lastly, sir, entering the caveat, does it mean that
yes.
does it mean that the vessel is protected from being arrested?
In a way, yes. But then it depends on some factors. For instance, where the fact that you filed a caveat does not insulate an arrest. But then a party must not go on to arrest the vessel without serving you a copy of the arrest application. So the moment you get to court, if the claim of the intending plaintiff is higher than the amount caveated for, then the court may still go ahead to arrest. But usually what they do is to now send you they give you like 3 days. They serve you a copy of the caveat. They serve you a copy of the caveat and say, a copy of the application on the caveator. Let's say you are the one that filed the caveat. They must serve you a copy of the application saying they are giving you 3 days. You have caveated $1 million, but they are claiming $1.5 million. Are you ready to give the $1.5 million, or we proceed to arrest your vessel? So that gives you an advantage. You quickly have to come up with the requisite guarantee or any of the specified 5 forms of security that we are devised.
Okay, thank you so much, sir. Thank you for answering all questions succinctly. Please, Obatayo, I know, can you send your question to the group or check the chat? There is a way you can join the group so that we can pass it across to Mr. Ayo Olorunfemi SAN. The time is fast spent and we would not want to keep anyone waiting longer than usual. Thank you so much, sir. Most importantly, if you did not get anything from the conversation tonight, there is one thing that I want you to hold on to is the fact that when you're talking about shipping and vessel, you should not put an action in rem and personal as a combination in the same originating summon. So you should remember that. If at all you don't remember anything from the conversation tonight, thank you so much, everyone. First, I would want to say thank you once again to Mr. Ayo Olorunfemi SAN for your time and for impacting us with this knowledge for the past 1 hour, 30 minutes. I would also want to say thank you to Mr. Johnson Babalola, who is the founder of JBLLC and has given us the platform to be able to moderate this session tonight. Also, thank you to every other person who has attended, judges, senior colleagues, and even people who are still students from various universities across Nigeria. And for people that dialed in from outside the country, thank you for joining us. We hope we are going to be able to be a part of our next mentorship session soon enough. You would stay connected with us on all social media. The link is already in the chat box as pasted. You can follow us on LinkedIn, on Twitter, on Instagram, and you can also be a part of the JBLCC mentorship to also get to be a part of the journey and experience something as insightful as this. Thank you so much once again, everyone. Thank you. And I hope
Thank
you
you very
have,
much, Khadija.
yeah, thank you, sir. I hope you have a wonderful Sunday and the rest of the week too. Thank you.
Thank you, everyone, for joining. God bless you.